Hello and welcome to BYJU'S Exam Prep. Welcome to our daily Hindu analysis. Let's begin the analysis of today's The Hindu newspaper by taking up a column from page number 6 of the Delhi edition. This column, written by R.K. Vij, a former IPS officer, deals with the misuse of anti-dowry laws and a recent ruling of the Allahabad High Court in this regard, which according to the writer marks a case of judicial overreach by the court. And this gives us an opportunity to talk about the dowry laws in India, along with its potential misuse and the court directions in this regard. It also gives us an opportunity to understand what is judicial overreach and how it could affect the doctrine of separation of powers. So before we look into the details of the article, first let's understand what is judicial overreach. See, in simple terms, judicial overreach is nothing but an instance where the judiciary is overstepping its jurisdiction and is seen to be stepping into the domain of the executive and the legislature. Another related term, which is often used along with judicial overreach, is judicial activism. See, there is a thin line that divides judicial activism and judicial overreach. Judicial activism refers to the use of judicial power to articulate and enforce laws which are in the interest of the society, even when the law per se doesn't provide for those provisions. In case of judicial activism, the judiciary would have taken upon itself to proactively remedy the flaws in the legal mechanisms, and in the larger interest of the society, the judiciary will not hesitate to step outside of its domain and to give directions to the legislature and the executive to ensure that the larger interests of the society are protected through a wider interpretation and enforcement of existing laws. This is referred to as judicial activism, which is seen as a welcome move by the judiciary, especially when the legislature and the executive are seen to be failing at their tasks. But however, judicial activism could easily turn into judicial overreach because, as I mentioned, there is a very thin line that divides the two. In fact, even understanding the differences between judicial activism and judicial overreach is seen as a matter of subjectivity or perspective, because in several cases of judicial activism, it could be easily interpreted as a case of judicial overreach by the other stakeholders, such as the government or by the legislature. See, judicial overreach is a case where the judiciary starts interfering with the functioning of the other organs of the state, that is, the legislative and the executive organs. So, if the judiciary is seen to be overstepping its mandate and jurisdiction, and if it is seen to be entering the domain of the executive and legislative functions, then this is defined as a case of judicial overreach, which is not a healthy sign in a democracy. Because the very foundation of a constitutional democracy rests on the fact that the executive, legislative, and judicial powers have been clearly separated as per the doctrine of separation of powers. In the case of Indian judiciary, especially at the level of high courts and as well as at the level of the Supreme Court, there have been several proactive interventions that the courts have carried out in order to protect and uphold the larger interests of the society. While these cases of judicial activism have been appreciated, there have been several cases of judicial overreach as well, which have led to criticism against the Indian judiciary. For example, the Supreme Court declaring Section 377, which dealt with homosexuality, as unconstitutional, is seen as a case of judicial activism because when it came to the basic fundamental rights of homosexuals, the executive and the legislature were seen to be failing to uphold them, and hence the direct intervention of the court was seen as necessary, and it is often interpreted as a case of judicial activism. So this landmark ruling of the Supreme Court in the Navtej Singh Johar case, which declared Section 377 as unconstitutional and led to the decriminalization of homosexuality, is upheld as a case of judicial activism by the Supreme Court. On the other hand, the rulings of the courts in cases such as imposition of national anthem in movie theatres, or the ban on firecrackers imposed by the court, or the ruling by a constitutional bench of the Supreme Court which declared NJAC and the 99th Constitutional Amendment as unconstitutional, these are seen as cases of judicial overreach. In the NJAC case, for example, the Parliament had provided for an accountable and transparent judicial appointment process to the higher judiciary through the 99th Constitutional Amendment in order to replace the opaque collegium system which is followed by the higher courts. But the Supreme Court took upon itself to override the Parliament in this case and declared NJAC and 99th Constitutional Amendment as unconstitutional. This was seen as the judiciary's excessive interference into the jurisdiction of the Parliament, and it is interpreted as a case of judicial overreach. But in its defense, the judiciary has always maintained that it has stepped into the domain of the legislature and the executive only under special circumstances where the executive and legislature were not fulfilling their expected responsibilities and where there was an underreach of the executive and the legislature. But either ways, judicial overreach is not healthy in a democracy as it steps on the jurisdiction of the legislature and the executive, and it leads to the violation of the doctrine of separation of powers. So with this understanding, now let's come back to the article and understand the recent ruling of the Allahabad High Court in a marital dispute that involved allegations of dowry. And in this case, the Allahabad High Court has taken upon itself to prevent the misuse of Section 498A of the Indian Penal Code that contains very stringent provisions for dealing with dowry-related cases. While the practice of dowry has been a social evil in India, and a strong legal mechanism like Section 498 of IPC was necessary to fight the social evil, the shortcomings of the law, however, has led to several instances where the dowry laws are misused, thus leading the courts to intervene to place restrictions on the application of dowry laws. See, in the latest case that came up at the Allahabad High Court, the court has sought to put in place a few safeguards to prevent the misuse of dowry laws, and it has issued a set of directions to the government and the police that needs to be followed in dowry-related cases, especially while acting against the accused. See, generally in dowry cases, the accused happen to be the husband, then of course, the in-laws or the parents of the husband, and in many cases, relatives of the husband's family as well. But there have been several instances where, in dowry cases, wide sweeping allegations have been made, not just against the husband and the in-laws, but also against a wide set of relatives, that leads to the immediate arrest of all the accused as soon as a FIR is registered by the victim. And in this regard, Section 498A of IPC is so stringent that the accused will not be even eligible for bail. So while such stringent laws are necessary to fight the social evil of dowry, it is also equally important to prevent its misuse. And in this regard, the Supreme Court has already laid down few restrictions in several landmark cases. For example, in the Social Action Forum for Manav Adhikar versus Union of India case 2018, and as well as in the Rajesh Sharma versus State of UP case of 2017, the Supreme Court had dealt comprehensively with the potential misuse of dowry laws, and these guidelines of the Supreme Court were serving as a benchmark for the police and the government to proceed with regard to dowry cases. Through these rulings of the Supreme Court in the Manav Adhikar and Rajesh Sharma case, and as well as in several other dowry-related cases, it has been established that dowry cases will be first referred to family welfare committees as soon as the FIR is filed, while the police can proceed to arrest the accused in case of any physical violence. Only if there is no tangible physical violence that can be recorded by the police, only then the accused will not be arrested while the case proceeds. And finally, based on the findings of the police and the report of the Family Welfare Committee, the case goes for hearing. In case there is no physical violence or abuse of the victim, the Family Welfare Committee proceeds to settle the dispute through the route of mediation between the family members, while allowing the police to take strict action against the accused in case of notable injuries and violence. So such safeguards established by the Supreme Court is set to strike a balance between the rights of the victim and the accused in dowry-related cases. But the Allahabad High Court, in its recent ruling, has gone against this established judicial precedents, and it has directed that in every district, a family welfare committee shall be set up under the District Legal Services Authority. And to prevent the misuse of dowry laws, the Allahabad High Court has ruled that once an FIR is filed, the police should immediately hand over the report and the case to the Family Welfare Committee, and the powers of the police to arrest the accused immediately has been curbed with a cooling off period for 2 months. That is, even in cases where injuries or violence is noted, the police will not be able to arrest the accused and they will have to wait for a report from the Welfare Committee. So these recent orders of the Allahabad High Court not only goes against the established precedents through various Supreme Court rulings, but it also steps into the domain of the executive and the legislature. The writer argues that while the Allahabad High Court might have the right intention to settle maritime disputes through mediation in the larger interest of the society, while trying to prevent the misuse of dowry laws, but its decisions to go against the orders of the Supreme Court in the Manav Adhikar case and the directions it has issued to the government and the police violates the jurisdiction of the executive, and hence the writer calls it a case of judicial overreach by the Allahabad High Court. Now let's take up a column from page number 7 that deals with the controversial Section 66A of the Information Technology Act. See, Section 66A of the IT Act is no longer present in our statute books. The IT Act that was enacted in 2000 provides for the regulation of electronic commerce and information technology in the country and also deals with all forms of cybercrimes. Under this law, there was a very controversial provision, that is Section 66A, that provided strict punishment for those who were sending offensive messages through communication devices and communication networks. The problem with this provision was that it provided a very broad, open-ended, undefined interpretation of offensive messages, thus giving rise to a lot of discretion or subjectivity to the police and the authorities at the ground level to interpret and determine as to what constitutes offensive. See, just stating that offensive messages sent through communication services is punishable is open to a wide interpretation because there is a lot of subjectivity or discretion involved over here. Without a specific definition, the police and the authorities who are going to enforce the laws, they are going to apply a wide interpretation, thereby resulting in the wide misuse of the law. The term offensive itself is very subjective because what is offensive to one person may not be offensive to the other. So unless and until the law specifically defines what constitutes offensive, the police and authorities are going to apply their discretion, thereby resulting in the misuse and abuse of the law. And that is exactly what was happening with Section 66A of the IT Act. Under this notorious provision, several innocent civilians were arrested just for posting messages, and it had also become a tool in the hands of the ruling parties to target any opposition or dissent. So following several cases of abuse of this law, in 2015, the Supreme Court finally stepped in the landmark Shreya Singhal case and declared Section 66A as unconstitutional and as draconian. The Supreme Court ruled that this provision was violative of free speech, which is a basic fundamental right guaranteed under Article 19, and such a discretionary open-ended provision will end up having a chilling effect on the fundamental right. Because with the existence of such a provision, then the citizens would be worried about freely and openly expressing their opinions, as they fear being arrested by the police for their statements. And such limitations on exercising fundamental rights based on the basis of fear falls under the coverage of doctrine of chilling effect. That is, just the fear of being targeted under such laws will lead the citizens to curb their own fundamental right to free speech and expression, which essentially ends up having a chilling effect on their fundamental right. So the Supreme Court invoked the doctrine of chilling effect and declared Section 66A as draconian and violative of free speech, and the law was struck down as unconstitutional. The Supreme Court had observed that opinions, no matter how uncomfortable and unpopular they are, they lie at the very heart of the democracy. And even if it means criticizing the government or politicians or elected leaders, this right cannot be curbed or curtailed unless and until speech and expression is leading to the direct incitement of violence and disruption to public order. As long as there is no threat of this, it's a fundamental right of every citizen to criticize the government, express their opinions freely. And in this context, Section 66A was seen to be unconstitutional. But shockingly, since 2015, Section 66A and a few related provisions have still been applied with the police and authorities even after the rulings of the Supreme Court. And now, the government of India has provided a recommendation to the United Nations, which is currently negotiating an international treaty to combat cybercrimes, to include a provision in the proposed international convention, which is chillingly similar to Section 66A of the IT Act. India, which is also taking part in these negotiations, has suggested to the UN that there should be a provision to criminalize offensive messages. And this has led to an argument that the government is trying to bring back this notorious provision through the back door, that is, through the route of the United Nations and an international treaty. So the writer of the column examines the possibility of resurrecting this law, which no longer exists in our statute books thanks to the timely intervention of the Supreme Court. So to combat cybercrimes, we still don't have a global convention or an international treaty, and currently the UN is considering one such proposal. And India has suggested that there should be a provision in the international convention to deal with offensive messages. And India has stated that there is a need to criminalize offensive messages. So the writer is examining whether it would be possible for the Indian government to reintroduce this law again through the route of the United Nations Convention. See, first and foremost, such a recommendation by India will not be accepted by the other members of the UN, especially by European countries. Countries which give a lot of importance to free speech and fundamental rights, they would never accept such a provision. So most likely India's recommendation is likely to fall apart at the United Nations. And second, even if this provision makes it to the international convention, then it is still unlikely that the provision can be introduced into Indian law. Because India is a dualist state and not a monoist state. A dualist state is a state where international law automatically doesn't become a part of domestic law. For international law to be introduced in the domestic context, a separate law should be enacted by the parliament. Whereas in a state where monism is practiced, international law automatically becomes part of domestic law. But this concern does not exist for India because in India, international law is not automatically applicable. For incorporating international law, a separate law has to be enacted by the parliament. The Indian judiciary, on the other hand, is unlikely to accept any such international law into domestic law because the court itself has ruled out such a provision as unconstitutional in the Shreya Singhal case. See, the Indian judiciary, especially the Indian Supreme Court, it has taken precedence from international law in several landmark cases. For example, in the Vishaka case, in the K.S. Puttaswamy case, where right to privacy was upheld as a fundamental right. And even in the Nalsa case of 2014, where the fundamental rights of transgenders was recognized by the court. In all these landmark cases, the court has taken direct references from international law. But this was done only when international law was not in conflict with domestic law. But the proposed provision on criminalizing offensive messages to deal with cybercrimes will not be accepted by the Indian judiciary because it is in conflict with domestic law, because the judiciary itself has upheld this provision as unconstitutional in the Shreya Singhal case. So even if this provision was adopted into the international treaty or convention, it is unlikely to be accepted by the Indian judiciary. And the only route that would be available for the government would be to enact a separate law in the parliament by invoking the constitutional provision of Article 253. Because Article 253 of the Constitution empowers the Indian Parliament to enact a law in order to ensure that India is in compliance with international laws and international treaties. But even such a law enacted, which might bring back Section 66A in a different form, it will still be subjected to judicial review and it can be challenged in the court, and most likely the court will again strike it down as unconstitutional. So unless and until the Shreya Singhal judgment is overturned by a higher judge bench of the Supreme Court, it is unlikely for the government to introduce such a provision to curb free speech and expression. Now let's take up another column from page number 7, in which the writer examines the recent promise made by Prime Minister Modi to create 10 lakh jobs in the next 18 months in the government sector. For this discussion, first we need to gain an understanding of the employment crisis in the country and in what context has the Prime Minister announced this employment scheme. See, just last week, Prime Minister Modi announced that government agencies and institutions will recruit around 10 lakh people on a fast-track basis in the next 1.5 years in order to drive up employment and to address the employment crisis that is facing the country. See, even though recent data has painted a positive picture about the employment status in the country, many experts have suggested that if you look at the long-term data, it is very evident that the country is staring at a massive job crisis or an employment crisis. The biggest concern is that the Indian economy has not been generating enough jobs to match with the demands of India's demographic dividend. As more and more young people are entering the workforce, they are finding it difficult to secure jobs, and their job prospects have been further hit, especially because of the shock created by the pandemic. According to data from the latest periodic labor force survey, which is brought out by the Ministry of Statistics and Program Implementation, India's unemployment rate has plunged to 4.2% in 2020-21, even as India witnessed two major waves of the pandemic during this period. The pandemic and the lockdowns disrupted the Indian economy and left millions of workers jobless, and since then the crisis in the Indian economy has deepened. But the latest data from the government suggests that employment situation is slightly improving in the last few months, especially when compared to employment data from the last 2 to 3 years. Because between 2017 and 2019, unemployment levels were much higher as compared to what it is now. But despite these positive figures, it is a given fact that joblessness in the Indian economy continues to remain a threat to the very macroeconomic foundation of the Indian economy. Because joblessness has hit not just the formal sector, where around 10% of India's workforce are employed, but even the informal economy has been badly hit. And this is a very serious risk, as nearly 90% of India's workforce is employed in the informal sector, that largely comprises of poor, semi-skilled and unskilled workers. See, back in 2014, Prime Minister Modi came to power on the promise that the new government is going to create around 2 crore jobs in the country in the coming years. According to a recent report by a consulting firm, around 9 crore new jobs will have to be created, that too in the non-agriculture sector by 2030, in order to satisfy the demands of India's demographic dividend. In the latest budget, the government has announced that it aims to create 6 million jobs, that is 60 lakh jobs over the next 5 years, which in itself is a massive target to achieve. Earlier this year, the government of India had informed the parliament that there were around 8.7 lakh job vacancies within the central government in various ministries and departments. So possibly, considering the employment crisis, the government is looking to fill these numbers. And it is these jobs that the Prime Minister could be referring to in the new scheme that the government has announced. This, according to the writer, is a positive sign, because to deal with such a massive unemployment crisis, the initiative has to be led by the public sector, that is by the government, and hence he calls upon the government to re-establish itself as the principal employment generator in the country, so that the labor market can be shielded from the shocks created by events like the pandemic. See, for India to overcome its employment crisis, India will have to make more investments, both from public and private sector, with special focus on labor-intensive industries such as construction, infrastructure creation, etc. There should also be greater focus on increasing female workforce participation, which currently happens to be one of the lowest in the world. According to reliable estimates, around 12 million people are hitting the employment age in India every year, whereas the Indian economy has not been able to absorb this labor force, thus creating a huge mismatch between the number of people looking for jobs and the number of jobs that are available in the economy. Upon this, the economy and the labor market have been hit very badly by the pandemic and the shocks created by it. And such chronic rising unemployment can be devastating for an economy which is still recovering, because this will lead to a drastic decline in demand that in turn leads to the overall deceleration of the economy itself, which ends up shaking the macroeconomic foundation of the economy. So it is in this context that the writer welcomes the announcement made by Prime Minister Modi to hire 10 lakh people into government institutions in the next 1.5 years. But he also points out that such temporary arrangements will not address the challenge. And for this, the government will have to scale up its investments, and it has to again emerge as a leading employment generator in the country. Because this will spur demand and also lead to an increase in private investment, which can then help in breaking the vicious cycle of rising joblessness and low demand. Next, we shall look at this column from page number 6, written by former Vice President Hamid Ansari. Hamid Ansari talks about India's diversity, that is its religious, ethnic and linguistic diversity, and how attempts are being made in the recent past by radicals and by fringe elements to exploit the diverse religious, ethnic, and linguistic profile of India. He argues that for India to remain strong and successful, it needs to celebrate and embrace its diversity as it has been done in the preamble to the Indian Constitution. In the preamble to the Constitution, the people of India has solemnly resolved to constitute India as a sovereign, socialist, secular, democratic republic which guarantees basic rights related to justice, liberty, equality, and fraternity. According to the writer, it is these principles enshrined in the preamble to the Indian Constitution, accompanied with the fundamental rights that give effect to these principles, that make India a thriving, functional democracy despite the differences, because the Constitution and we as a nation have imbibed the principles that are enshrined in the preamble. Then, coming to the last topic, we have an article on page number 14 that refers to the Finance Ministry's monthly economic report, which paints a broad picture regarding the status of the Indian economy for the month of May. In the report, the Finance Ministry has acknowledged that the Indian economy is facing near-term challenges, and particularly the risks to fiscal deficit target after the recent cuts in excise duty on petrol and diesel has been flagged by the ministry as a concerning development. In this monthly economic report that is brought out by the Finance Ministry has observed that the Composite Purchasing Managers Index has risen to its highest level in the last 1.5 years, thereby indicating a recovery in the manufacturing sector. It points to revival of industrial growth, following several months of negative growth and stagnation as a result of the pandemic and the lockdowns. The report points to clear signals of economic recovery that is underway, and it observes that India is likely to sustain the growth momentum in the coming quarters. According to the Finance Ministry, growth levels have almost returned to pre-pandemic levels, and GST collection has gone up significantly as compared to the previous year. Even rural income has registered a significant growth as a result of high agricultural exports and due to hike in MSP prices for Kharif crops. Then another positive is that the report notes a significant jump in India's IIP or Index of Industrial Production, and especially significant growth is being registered in the manufacturing sector and in the 8 core industries of the IIP index. But however, the report does flag the concerns, especially the risk posed by the Russia-Ukraine war, not just to the global economy, but also to the Indian economy. Even as the Indian economy is on the path to recovery, several risk factors have emerged that further add on to the burden caused by the Russia-Ukraine conflict. The continued disruption in global supply chains, accompanied with high levels of inflation in India and around the world, along with unprecedented heat waves destroying agricultural production, pose a significant risk to growth prospects, as central banks around the world, especially the US Federal Reserve, have started tightening their monetary policies by increasing interest rates. And all these developments present a credible threat to the global economy and as well as to the near-term prospects of the Indian economy. The report also expresses concern about widening trade deficit as India's imports have gone up, with only a nominal growth being registered in Indian exports. The report also flags a concern with regard to India's fiscal deficit target and points out that the government might miss the fiscal deficit target as a result of the recent tax cuts, that is, the reduction in excise duty that the government has announced in order to bring down the prices of petrol and diesel. So these risk factors create a near-term risk for the Indian economy, but however, the report observes that in the medium to long term, India's growth prospects are very stable and positive. And thankfully, economic activities in the agriculture sector, in manufacturing, and even in services have all bounced back to pre-pandemic levels. Now let's take up a couple of mains practice questions before we end the session. The first question, what do you understand by the term judicial overreach? Examine in the context of Allahabad High Court's recent directions regarding misuse of Section 498A of the Indian Penal Code. The second question, critically evaluate the controversy surrounding Section 66A of the IT Act with emphasis on the Supreme Court's ruling in the Shreya Singhal case. Kindly write an answer to these questions and post your answers in the answer writing portal, for which the link has been given in the description box below. So with this, Let's conclude our discussion for today. And if you like the initiative, do let us know by pressing the like button, share the video with fellow aspirants, and don't forget to subscribe to our channel. Thanks for watching.